Another category of authority of the agent is apparent authority. And that is the authority that the agent or the principal expresses to third parties. So say the agent claims that he or she has authority to undertake a particular action. There's no title, there's no past course of conduct where this would be implied. It is simply stated by the agent to a third party that I have this authority. But in reality, the agent does not. If there is some level of conduct by the employer or some inaction by the employer to remedy this situation, to limit the scope to which the agent can express their authority, or to make others, third parties, aware that an agent has a limited level of authority. Any of these gives rise to the third party believing the agent's representations, believing that the agent has this level of authority. Then the agent will be deemed, again, under principles of equity or law, to have this authority. Now, where does this come from? The idea is that a third party believes an agent because, one, there's a representation there, and because the principal, the employer in our scenario, has done nothing to limit the agent's ability to represent that, has done nothing to put the world on notice that this agent does not have that authority, then the responsibility should most fairly rest on the principal if this third party indeed believes that the agent has this level of apparent authority. So to summarize, an agent's authority to act on behalf of the principal, and thus the principal's responsibility for the actions of the agent, is related to either the expressed authority, the implied authority, and together these are forms of actual authority. And then there's apparent authority, and that is based upon what is reasonably perceived by a third party, based upon the representations of the agent. With that being said, that summarizes the scope of an agent's authority.